Delivery of order. Item number 1.
For reasons mentioned in the order, this interlocutory application is dismissed.
Mention it.
Your Honor, in item number 5, as per the Honorable Court direction, we have filed our additional affidavit, but it's not been tagged with the record, so it may be allowed to read.
Yes, bring that on. Okay, it will be called.
With regard to item number 43, my lord, it is wrongly listed in the hearing column, my lord. It was listed on 16/2/2026 in the mediation, reference for mediation, my lord. I took time for seeking instruction from the insurance company, my lord. Insurance company is ready to settle the matter, my lord. And I, with the consent of my learned friend, my lord, the matter may be fixed for Lok Adalat, which is fixed on 14th March, my lord.
Item number
43.
heard Mr. V.K. Borwa, learned counsel for the appellant. Also heard Mr.
Miss K.L.R. Yanthan.
Miss K.L.R. Yanthan, learned counsel for the respondents / claimant. It is submitted at bar that there is a possibility of reaching amicable settlement between the parties, and therefore it is requested by learned counsel for both the parties that the matter may be referred to Lok Adalat, referred to the ensuing Lok Adalat on 14/3/2026. The prayer is allowed. List this matter before the Lok Adalat on 14/3/2026.
Highly obliged, Lord.
Yeah, please, Your Lord. My lord, I am for item number 44, my lord. This matter may be adjourned for the day, my lord.
You have informed the other side.
Yes, my
Yes,
lord.
Lordship, kindly short date may be given.
Well, after March, my lord.
Mr. What is your name?
Yes, sir, Lord.
Heard Mr. S.R. Borbia, learned counsel for the respondent. Also heard Miss S. Sheikh, learned counsel for the appellant. Learned counsel for the respondent prays for an adjournment on the ground of personal difficulty, to which the learned counsel for appellant does not raise any objection. Hence, the prayer is allowed. Let this matter be listed on 7th of April.
No.
May I please, Your Honor? I beg to mention for listing of MSc April, my lord, since pending 2022. It was last listing on the month of November.
In orders column, it will be listed.
It is in admission column. Steps are already been completed, and claimant is in a critical condition, my lord. That's why
The appeal is not yet been admitted,
already admitted.
so it will go to hearing column.
Lordship, last occasion was for the service of notice of.
Or orders 5th of March.
Obvious.
Lordship, I beg to mention item number 25, Lordship.
Yes.
Conducting counsel J.C. Bora has informed me over the phone that he is out of station, as he has been appointed as assistant public prosecutor.
Heard Mr. What is your name?
K. Mujumdar.
K.
Mujumdar.
Mujumdar, appearing on behalf of Mr. J.C. Bora.
2 weeks time maybe.
Submit praise for 2 weeks time. Praise for an adjournment for 2 weeks on the ground that the conducting counsel for the applicant is out of station. The prayer is allowed. Let this matter be listed on 25th of March.
May it please your lordship, I beg to mention item number 8. Due to a medical emergency, learned counsel D.D. Burman is out of station. Matter may be passable for the day.
Heard Miss, what is your name?
G. Kashyap.
G. Kashyap, learned counsel for the appellant, who seeks an adjournment on the ground that the engaged counsel for the appellant is indisposed. Considering the grounds shown by the learned counsel, the prayer is allowed. Let this matter be listed on 19th of March.
Highly.
Lordship, I beg to mention criminal petition, Lordship. Lordship, it was last listed on.
Criminal petition, separate bench.
May it please your lordship. Your lordship, I beg to mention listing on regular past April, your lordship. It's 2012 matter. Last it was listed on 6/10/2023, lordship.
Orders 5th of March.
Okay.
Please, your lordship. My lord, with concern of the applicant, I beg to mention item number 29. My lord, in this case, my lord, we need to file, my lord, a objection, my lord. So, my lord, 10 days time may be granted, my lord.
Lord Mr. M. Islam, learned counsel for the respondent, who seeks some time to file written objection against the interlocutory application filed by the applicant/appellant. He submits that he has informed learned counsel for the applicant regarding his prayer for adjournment, who has no objection to his prayer. Stop. The prayer is accordingly allowed. Let this matter,
Date after 19, my lord.
23rd March.
May it please your
Highly
lordship.
obliged.
I beg to mention item number 4 of today's list. Lordship, let this matter be taken up on Monday. We are appearing for the appellate.
You have informed the other side.
This is a new matter.
New
This is
matter.
not-
Okay. Third, Mr. S. that the learned counsel for the appellant, on request of the learned counsel for the appellant, this matter is listed on 2nd of March.
Obliged.
May it please your lordship. Your lordship, I beg to mention listing of 2 MFAs for orders in the second week of April. Any date on the second week of April for orders.
Give it 8.
April, second week of April.
2nd of April.
Hello.
Lordship, I beg to mention item number 22, Lordship. This matter may kindly taken up on the next week, Lordship.
22 why?
Lordship, some corrections are needed to be made in one of the IA, Lordship.
Third, Mr. S.P. Sharma, learned counsel for the applicant, who submits that some corrections are to be made in one of the interlocutory application filed by the present applicant. Hence, he seeks some time for the same. The prayer is allowed. Let this matter be listed on 6th of March.
I beg to mention item number 5, your lordship. Today we'll be filing our objection against the application that they have filed. The lordship made a matter be fixed for Monday.
Who is for the,
Lordship, I am the respondent. Ajit Das.
Objection.
what is your name?
R. Chaudhary.
And here.
Heard Mr. N. Bhuya, learned counsel for the cavator/respondent, who seeks some time for filing written objection in this appeal. Written objection against the interlocutory application filed by the applicant. Mr. What is your name?
R. Chaudhary.
Mr. R. Chaudhary, learned counsel for the applicant, does not raise any objection. Hence, the prayer is allowed. Let this matter be listed on
5th of March.
Monday.
Sorry, 2nd of March.
2nd of March.
Second of March.
March.
Obliged, much.
Wait, please, your lordship. These 4 meters, they have not been listed for last 3 or 8 years. They may come for order.
6th of March. 6th of March.
May please your lordship, I beg to mention item number 19, 20 and 21, lordship. Lordship, matter was filed for modification, but now appellant does not want for further proceeding, lordship. Kindly matter may be withdrawn, lordship. Item number 19, 20 and 21, orders matter, lordship.
What is your name?
J. Kolita.
Heard Miss J. Kalita. Separate order hobo tinita. Heard Miss J. Kalita, learned counsel for the appellant who prays for allowing the appellant to withdraw the instant appeal. The prayer is allowed. This appeal is dismissed on withdrawal.
Lordship, LC, there is LCR, so LCR.
Let the records of the trial court let the records of trial court be sent back immediately.
Obliged.
motion দিয়ে item 2
May it please lordship. If TCR may be called for lordship.
What is the matter?
NDPS, commercial quantity.
What is the ground?
The ground is the lordship. First ground is the lordship, illegal detention is the new ground lordship. I was arrested on 2nd of September and I was produced on 4th of September lordship. 1/3 on the pretext of taking voluntary statement, but it was not taken lordship. I was taken the illegal custody lordship till 4th, and on 4th I was produced before the court lordship, and not.
Have you raised this issue before the magistrate before whom you were produced?
Not meant, not.
Okay. What else is your ground?
And next, second ground is bank statement lordship. Bank statement is submitted because nothing was recovered from me, and I was not present. I was subsequent was arrest was conducted against me lordship. Then bank statement, regarding bank statement, 65 certificate is not enclosed lordship, and CDR also regarding 65 certificate is not enclosed.
Charge sheet has been filed.
Yes, lordship. Charge sheet matter.
Charges framed.
No, lordship.
These. Yes.
Here I'm appearing on behalf of Mr. R.K.D. Chaudhary. He's in leave today, lordship,
Union of India is the party.
or NCB, lordship.
Or NCB, okay.
Notice me.
You have received the copy. Heard Mr.
M.
M.
Rahman.
M. Rahman, learned counsel for the petitioner. Also heard Miss L. Devi, appearing on behalf of Mr. R.K.D. Chaudhary, learned Deputy Solicitor General of India. This application under section 483, why it has come to this court?
Second bill application.
This application under section 483 of BNSS 2023 has been filed by the applicant, by the petitioner, Jahia Khan, who has been detained behind the bars since 4/9/2025. Stop. Let the scan copy of the records of special NDPS case number 13/2026 along with the scan copy of the connected case diary be called for from the trial court registry to take steps for requisitioning the record. List this matter on
It will be too long. It may be
shorter date.
13th of March. 13th of March.
Not as a 13.
13th of
13th March.
13th March. Yes, Lord. Obliged.
for refer to special mediation trial item 3
Obliged.
May please your lordships, my lord petitioner wants to go to the mediation, so let the matter be placed before the mediation.
And the other side?
Not yet appeared, ma'am. I have taken steps, ma'am.
Okay. Miss K. Devi, learned counsel for the appellant, who submits that the respondent is yet to appear in this appeal. However, she is hopeful that an amicable settlement may be arrived at between the parties, and therefore she submits that this is a fit case to be referred to the mediation. Accordingly, let this case be sent to Guwahati High Court Mediation Center for mediation. The parties shall appear before the mediator to be assigned by the Guwahati High Court Mediation Center after receipt of notice from the Guwahati High Court Mediation Center. Let this matter be listed for report of the mediator after 3 months. 3 months. 2 months. Let this matter be listed on 6th of May.
Oblige your lordships.
Item 6.
Met with the law. My lord, this appeal has been filed against the impugn order dated, my lord, 11/2/26, passed by the learned Civil Judge Senior Division 1 Gauhati, whereby, my lord, an ex parte pre-trial restraint order has been passed. Now, my lord, if your lordships would kindly come to page number 34. 35, sorry, my lord, of the FAO, my lord. 35 of the appeal, my lord, memo. These are the, my lord, these were reported in the newspaper. That in the aforesaid defamatory news item dated 5/2/26, written, printed, published and circulated by above name defendant number 4 to 7 in their newspaper Ahomia Proceedings under the heading Rajyot Name Bename Sampotti Kroy Mukhyamantri.
Who are you?
I am the, my lord, newspaper, my lord, Proceedings.
Okay.
Rajyot Name Bename Sampotti Kroy Mukhyamantrir পৰিয়ালৰ 12,000 বিঘা ভূমি হিমন্ত বিশ্বক কাৰো নহয় যাৰে ঘনিষ্ঠ হৈছে তাৰে পিঠি চুৰি বহু চাইছে. Reprehensible insinuation had been casted upon the plaintiff herein, leveling allegations and accusations which may be summarized as under. Plaintiff and his wife have brought in their name 12,000 vigas of land. Plaintiff and his wife purchased such amount of land in nook and corners in their name, and that the exact amount of which is still unable to be quantified. Plaintiff here is an impolite and arrogant chief minister. He is a family businessman and land grabber, most corrupt chief minister, traitor, betrayer, politician. He is a liar chief minister of all time, etc. Plaintiff has sold Assam. Plaintiff and his wife are doing business by selling Assam. Plaintiff herein stabbed a former chief minister and became chief minister through backdoor. Plaintiff herein has imposed HBS tax in the state. Plaintiff is involved in Louis Berger, Sarada, etc., etc. Now, my lord, in different news items, my lord, or in this news item, these things were published. And this was addressed by other defendants before the, my lord, trial court. Now, what the trial court has done, my lord, trial court has referred to the, if a lordship now comes to the impugn order.
Where is the impugn order?
Yes. The impugn order, my lord, starts at page number 91. I'll have your lordship's kind attention to page 98 onwards. Page 98, my lord. Para 8 towards the bottom of the page. Bloomberg Television Production Service Private Limited and other. This is a case of Supreme Court which has been relied upon. Then Indian newspaper, Express newspaper case of 1986. Then my lord Umesh Kumar's case at page number 101. Then at page number 102, my lord Subramaniam Swami's case is relied upon. Then eventually my lord will kindly come to page 104.
When is the next date fixed? This order was an ex parte order.
Ex parte order. Yes,
Next date is fixed on 9th of March.
yes, yes.
You appear before the
No, my
trial.
lord. No, my lord, I'll prima facie show this is without jurisdiction. That I'll satisfy. Because the
Then-
standard
then
is
the-
not prima facie case in a defamation, my lord.
No, then we will have to issue notice to the
No,
respondent.
no, my lord, I'm praying for stay of this order. I'll try to satisfy your lordships, my lord. My lord, end of the day, the constitutional guarantees are much more above law of defamation, my lord. Like, when
No,
if-
we'll fix a very short date. Who is the, who are the respondents?
My lord, respondents are, actually, my lord.
When the order was passed,
Order was passed on 11/2/26. My lord, my only anxiety is, my lord, how can my right to publish can be
no,
restricted?
no, that will be addressed. But the question is, you have approached this court after, say, 16 days.
Yes.
So
In fact, my lord,
what is the urgency that without issuing notice, this court?
no, my lord, end of the day, people has a right to know. People are right under, in end of the day, my lord, Right to Information Act is founded on one. It is founded on Article 19(1)(a).
No, no, I'm not on that.
Yes.
On merit, you may,
Question is, my lord, people have.
you
right
are
to-
against an ex parte order.
Yes.
Relief cannot be again ex parte unless the waiving of notice is
My lord,
justified.
my lord, in that case, we'll fix a very short date, my lord.
Yes, I'm ready to fix a short date.
My lord, we'll fix it on 5th, my lord. We'll try to.
But you will
serve
be,
this thing.
you will have to
I will serve.
ensure the service.
On
Okay,
5th, my lord.
okay. Heard Mr. K.N. Chaudhary, learned senior counsel, assisted by Mr.
T. Kashyap, your lordship.
T. Kashyap, learned counsel for the appellant. This appeal under Order 43, Rule 1R of the Code of Civil Procedure, 1908, has been preferred by the appellants, namely 1, 2, and 3, impugning the order dated 11/2/2026, passed by the Court of Learned Civil Judge Senior Division number 1 in number 1 Kamrup Metro in Miss J case number 156/2026 in connection with title suit number 85/2025, whereby an ex parte ad interim injunction was granted against the present appellants. Learned senior counsel for the appellant has submitted that. No, yaten alikhbo. I issue notice to the respondent. Respondent. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 2 days from the date of this order, returnable on 5th of March. Stop. The
You may be permitted dasti also. By hand.
the appellant is additionally allowed to. No, appellant is
Defend respondent number 1.
appellant is allowed to take steps by way of dusty mode also upon the
Respondent number 1.
upon other respondents.
Well, other respondents will take steps, my lord. In fact, they are not, they are the pro forma, my lord. They were the The press conference was addressed by all these people.
Upon the respondent number 1,
Yes.
who is the plaintiff of title suit number 85/2026, the prayer is allowed. The appellant may take, prayer is allowed, stop. In the event the appellant is able to serve the notice upon respondent number 1 by dusty mode, the appellant shall file an affidavit in compliance thereto on the next date fixed. Let this matter be listed on fifth. In I also we are issuing notice. In I also same notice, same language, everything is same, 5th of.
7.
Diplop.
Please, Lord. Sure. This appeal has been preferred mainly on the ground that the deceased was a bachelor at the time of his death, and the Honorable Tribunal has deducted 1/3.
You are agreed with the quantum?
Yes, Your Lord.
Heard Mr. R. Sharma.
Yes, Sharma.
S. Sharma, learned counsel for the appellant. This appeal under section 173 of MV Act 1988 has been filed by the Oriental Insurance Company Limited, impugning the judgment and award dated 13/6/2025, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, and Gauhati, in MSC case number 878/2018. Stop. The appellant is aggrieved mainly with the quantum of compensation awarded to the claimant. Stop. This appeal is admitted. Let the records of MSC case number 878/2018 be called for from the concerned tribunal. The registry to take steps for requisitioning the records. Let the notice be issued to respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April.
Lordship, there is an I first day.
We are issuing notice.
Lordship will deposit 50%. It may be state.
Heard Mr. S. Sharma. S. Sharma.
Yes, sir.
This interlocutory application under Order 41 Rule 5 of the Code of Civil Procedure has been filed by the insurance company in connection with the MSC appeal number 76/2025, praying for stay of execution of the judgment and award dated 13/6/2025, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, in MSC case number 878/2018. Learned counsel for the applicant has submitted that the aforesaid judgment has been impugned by the applicant in the connected appeal. He also submits that said appeal has been admitted and notice has been issued to the respondent. He also submits that the applicant is ready to deposit 50% of the awarded amount as a condition for grant of stay to the execution of the impugned judgment and award. Stop. Considering the submissions made by learned counsel for the applicant, notice to respondents is waived and the prayer made by the applicant is allowed. The execution of judgment and award dated 13/6/2025, passed in MSC case number 878/2018 by the Motor Accident Claims Tribunal number 1, Kamrup Metro at Gauhati, shall remain stayed during the pendency of the connected MAC appeal number 76/2025, subject to deposit of 50% of the awarded amount within bracket total awarded amount of dash rupees 39,41,100 bracket close before the registry of this court
Within 6 weeks.
within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Item 9.
May it please, your lordship, this appeal is filed by the insurance company. My lord, what happened, my lord, in this case, the insured vehicle insured with the insurance company is was not at all involved in the This appeal is filed by the insurance company. My lord, the vehicle insured with the insurance company, appellant company was not at all involved in the accident. The insurance company's adduced dividends, but the learned tribunal did not consider this aspect of the matter.
Okay. Third, Ms. S. Roy, learned counsel for the appellant. This appeal under section 173 of Motor Vehicle Act 1988 has been filed by the National Insurance Company Limited, impugning the judgment and award dated 30/10/2025 in MAC case number 1594/2015 by the Motor Accident Claims Tribunal number 3, Kamrup Metro, whereby the appellant was directed to pay an amount of rupees 2,53,801 along with an interest at the rate of 7.5% per annum to the respondent claimant. Stop. I have gone through the grounds stated in the memo of appeal and have heard and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Call for the records of MAC case number 1594/2015 from the concerned tribunal. The registry shall take steps for requisitioning the aforesaid record. Also issue notice to the respondents. Only one respondent.
One respondent.
The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April.
I feel interim application.
I will issue notice. In I issue notice, same date.
Item 10.
Lordship, this is an statutory appeal, Lordship. In this case, what happened, the victim had sustained grievous injuries on 2/2/2022 in a motorcycle accident, Lordship, in Silchar. And he was referred to Gauhati by one ambulance. He came to Gauhati. On the way, that motorcycle, that ambulance met with an accident, Lordship. So it is projected by the claimant that he had expired due to the accident caused by the ambulance, Lordship. But our contention is that he had sustained severe injuries in the motorcycle accident. So there is no proximate cause of his death due to accident of the ambulance, Lordship. It is doubtful that he had expired in the accident caused by the ambulance, Lordship. In the motorcycle accident, he got such severe injury that he was referred to Gauhati by one ambulance that met with an accident. His wife also came along with him, but
he would not have died had the ambulance not met with the accident.
Accompanying persons, nobody got injured. It is doubtful that we have filed up appeals.
Heard Mr. A.J. Sakya, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by United India Insurance Company Limited against the judgment and award dated 19/11/2025, passed by the Motor Accident Claims Tribunal, Kachar, Silchar in MAC case number 115/2022, whereby how much amount was directed?
Lordship, 97 lakhs,
Whereby an amount.
97 lakhs,
whereby
8,860.
an amount of rupees 97,08,860, along with an interest at the rate of 9% per annum, was directed to be paid by the present appellant to the claimants, opposite party. I have gone through the grounds stated in the memo of appeal, as well as considered the submissions made by learned counsel for the appellant. The appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April. Let the records of MAC case number 115/2022 be called for. Call for registry to take steps for issuance, for requisitioning the records, list accordingly.
This one is to this one.
Will issue notice.
It may be state law, we are going to deposit 50%.
50% you are ready.
Yes, not to be withdrawn at this moment.
Lord Mr. A.J. Soikya, learned counsel for the applicant. This application under Order 41 Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant insurance company in connection with the MAC appeal number 79/2026, praying for stay of execution of the judgment and award dated 19/11/2025, passed by the Motor Accident Claims Tribunal, Kachar, in MAC case number 115/2022, whereby the present applicant was directed to pay an compensation amount of rupees 97,08,860 to the claimants / respondents, along with an interest at the rate of 9% per annum. Learned counsel for the applicant has submitted that the applicant has impugned the aforesaid judgment and award in the connected MAC appeal number 79/2024, which has already been admitted. He submits that in the said appeal, the notices are also issued to the respondents. He also submits that the insurance company is also ready to pay, also ready to deposit 50% of the awarded amount as a condition for stay of the execution of the impugned judgment and award. Considering the submissions made by learned counsel for the applicant, notice to the respondents is waived, and the prayer made by the applicant is allowed. The impugned judgment and award dated 19/11/2025, passed by the Motor Accident Claims Tribunal, Kachar, Silchar, in MAC case number 115/2022, the execution of the impugned shall remain stayed during the pendency of the connected MAC appeal number 79/2026, subject to deposit of 50% of the awarded amount by the applicant before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Obliged.
Item 11.
May I please, Your Lordship? It's an appeal against the award of MSIT Nogao, Lordship, by the insurance company, Lordship, whereby we have been directed to deposit an award of rupees 50,38,000, Your Lordship. Here, Lordship, our ground is it's a clear case of contributory negligence, Your Lordship. And this aspect.
Contributory negligence.
Yes, Lordship. This aspect was not considered during the trial, Lordship, whereas the evidence, clear evidence that there was a contributing negligence on the part of the deceased. And it is admitted by the PW1 that deceased was working as a night chowkidar in a go-down, Lordship.
Okay.
In a
Okay,
go-down.
heard Mr. P.J. Burman,
Lordship.
learned counsel for the appellant. This appeal under Section 173 of Motor Vehicles Act 1988 has been preferred by the National Insurance Company Limited, impugning the judgment and award dated 26/11/2025, passed by the Motor Accident Claims Tribunal, Nagaon, in MEC case number 146/2022, whereby the present appellant was directed to pay a compensation amount of rupees 15,38,000 along with an interest at the rate of 7% per annum. I have perused the grounds of appeal as well as considered the submissions made by learned counsel for the appellant. Stop. This appeal is admitted. Let the records of MSC case number 146/2022 be called for from the concerned tribunal. The registry to take steps for requisitioning the records. Let the notice be issued to the respondents. The appellant shall take steps for requisition for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 9th of April.
There is a stay application, Lordship, and we are ready to deposit 50%. That may be disposed of. Yeah, we are seeking 50% reduction in this case. We are depositing 50%, Lordship.
Mr. P.J. Burman, learned counsel for the applicant. This interlocutory application has been filed by the insurance company / applicant, praying for stay of execution of the judgment and award dated 26/11/2025, passed by the Motor Accident Claims Tribunal, Nagaon, in MSC case number 146/2022, whereby the present applicant has been directed to pay a compensation amount of rupees 15,38,000 along with an interest at the rate of 7% per annum to the claimant / opposite party. The learned counsel for the applicant has submitted that the aforesaid judgment has been impugned by the applicant in the connected appeal. He also submits that said appeal has already been admitted and notices are also issued to the respondents. He further submits that the applicant is ready to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award. Stop. Considering the submissions made by learned counsel for the applicant, the notice to the respondents in this interlocutory application is waived. and the prayer for grant of stay is allowed. The judgment and award dated 26/11/2025 passed by the MACT Nagaon in MAC case number 146/2022 shall remain stayed during the pendency of the connected MAC appeal number 80/2025, subject to deposit of 50% of the awarded amount by the present applicant before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Item 12.
Please, Lord. What should we prepare this appeal for quantum? But it is an admitted position that the deceased was a cleaner / labor at the time of accident. So the assessment should have been under the Employees Compensation Act instead of Motor Vehicle Act. And secondly, the offending vehicle was carrying 25 numbers of workers at a sitting capacity of only 2.
Where is the memo of appeal? Heard Mr. S. Sharma, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the Oriental Insurance Company Limited, impugning the judgment and award dated 4/4/2025 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MAC case number 1370/2018. Whereby a compensation amount of rupees 17,58,894.88 paisa was directed to be paid by the present appellant to the claimant respondent. I have gone through the grounds stated in the memo of appeal, as well as considered the submissions made by learned counsel for the appellant. This appeal is admitted. Call for the records of MAC case number 1370/2018 and issue notice.
Lordship, respondent number 2 and 3 are minors. They're represented by their mother, that is respondent number 1. So notice may not be issued to them.
No, issue notice to everybody.
They're represented by the mother.
No.
1.
Who will represent, we will see later on.
It is admitted in the claim petition.
The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 9th of April.
This is an I for stay here.
I
Deposit 50%.
You will deposit
Yes, sir.
same order, same pattern of 50%. Miss I is disposed of. Try Koribo.
Item 13.
Item.
Say appeal preferred by the insurance company, Lordship, against the order because Lordship, there was no valid permit and the insurance company adduced evidence on that behalf. However, the learned tribunal has applied the principle of pay and recovery, Lordship.
What tribunal did?
Like the principle of pay and recovery without the, without the principles as laid down by the apex court lordship in non-offense judgment. That is one of our ground lordships.
You pay and then recover.
Certain thing, they should pay and they should recover. It is already the
But there should be
landmark
some
judgment is
conditions,
given.
lordship.
May I please, I'm appealing for the respondent 1, 2, and 3. As this, we have filed,
Okay, we are issuing notice.
we have filed a wakalatnama. This morning it came to our
Okay.
notice.
Heard Mr. S.P. Sharma, Learned Counsel for the appellant. Also heard Mr. R. Goswami,
Respondent 1, 2,
Learned Counsel for respondent number
1, 2, and 3.
1, 2, and 3. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant insurance company, impugning the judgment and award dated 18/11/2025 passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, in MSC case number 1197/2022, whereby the appellant was directed to pay an amount of rupees 12,38,220 to the claimant respondent and thereafter recover the same from the owner. So,
Your Lordship, this is a case of composite negligence. 2 insurances are involved and the other insurances already without any contest has disbursed the amount to the claimant. So this is not a contributor. So the other insurances, 50% has already been deposited in the trial court.
We have made the other insurance party lordship. Let us-
So it is an inter-se
This is
dispute and inter-se adjustment. So, but the client,
it is submitted by Learned Counsel for the respondent that out of the awarded amount, the present appellant was directed to pay only 50% of the same, as the respondent number 5 insurance company was directed to pay the remaining 50%, which has already been paid by them.
Here it will be respond number 6, lordship.
Sorry, respondent number 6 instead of respondent number. I have gone through the grounds of appeal as well as considered the submissions made by Learned Counsel for the parties. Issue notice to the respondent. This appeal is admitted. Now let the records of MSC case number 1197/2022 be called for from the concerned tribunal. The registry to take steps for requisitioning the aforesaid records. Issue notice to the respondents. Since Mr. Goswami has appeared for respondent number 1, 2, and 3, no formal notice need to be issued to the said respondents. However, the appellant shall furnish requisite copies of memo of appeal along with annexure to the Learned Counsel for respondent number 1, 2, and 3 within 2 days from the date of this order. As regards other respondents, the appellant shall take steps for issuance of notice on them within bracket respondent number 4, 5, and 6 by register, by speed post as well as by usual mode within 7 days from the date of this order, returnable on 9th of April. List accordingly.
Lordship, there's a first stay. We are ready
So
to
we-
deposit 50%.
we vehemently object because this is a case of composite negligence. So 70% of the amount may be deposited because the other half has already been deposited. So it is quite normal presumption can be drawn that there shouldn't be any major drawbacks in this. It's a fair judgment. So 70%.
You are ready to deposit 50%,
50% of the 50%, lordship, because we are,
50% of your share.
yes, lordship.
Okay.
Because it's the adjustment, they can go for the adjustment interest dispute. I shouldn't suffer because I'm a third party, so 70% maybe this may be deposited. And And your lordship, with greatest respect, I just beg before just honor that lordship that along with this order, it may become that liberty may be given for the claimant, for the respondent to collect. What happened otherwise? Again, I lordship will give
Okay,
50% to be
okay,
considering
okay.
the plight of this, because other I will be filed and these are practices going on. They give their objection. I do not know what this happened.
Heard Mr. S.P. Sharma, learned counsel for the applicant. Also heard Mr. R. Goswami, learned counsel for the opposite party number 1, 2, and 3 / claimants. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 82/2026, praying for stay of execution of the judgment and award dated 18/11/2025, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, Gauhati, in MAC case number 1197/2022 during the pendency of the connected MAC appeal. Learned counsel for the applicant has submitted that the aforesaid judgment and award has been impugned by the present applicant in the connected appeal, and the said appeal has already been admitted, and notices are also issued to the respondents. He submits that in the aforesaid he submits that by the impugned judgment, how much amount? What was the total amount?
Total amount, lordship, 12,38,220.
By the aforesaid
Along with the
judgment.
interest. Interest is
Judgment.
also there.
The present applicant was directed to pay 50% of the awarded amount, that is 12,38,220, along with an interest at the rate of 6% per annum to the claimants, and thereafter recover the same from the owner. Stop. Learned counsel for the applicant submits that the applicant is ready to deposit 50% of its share to the registry of this court as a condition for grant of stay of the execution of the impugned judgment and award. Stop. On the other hand, learned counsel for the respondent number, opposite party number 1, 2, and 3 claimant has vehemently opposed the prayer. He, however, submits that if the court is inclined to grant this stay, at least 70% of the share of the present applicant may be asked to be deposited by them. And in event of such deposit, he submits that the applicant, the respondent, opposite party number 1, 2, and 3 / claimant may be allowed to withdraw the same. Stop. I have considered the submissions made by learned counsel for both sides. Since the applicant is ready to deposit 50% of the deposited of the share which it had to pay as per the impugned judgment and award, and since the claimants are represented before us, before this court, the notice to other respondents is waived. considering the submissions made by learned counsel for both the sides, this court is inclined to allow this interlocutory application. The 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 portion of the judgment, no, the execution of the impugned judgment against the present applicant shall remain stayed during the pendency of the connected MAC case, MAC appeal number 82/2026, subject to deposit of 50% of the amount which the applicant were supposed to pay in terms of the impugned judgment and award to the claimants within 6 weeks from the date of this order. Stop. In the event such a deposit is made by the applicant insurance company.
May I lordship one submission, lordship? Lordship, here this is a case where the owner is a inseparable party because pay and recovery factor is there. So my prayer will be that deposition is okay, but for withdrawal lordship, let the owner appear. This will be my Hamid's submission at this stage.
May please, your lordship, this has been given not as a security because this has been because considering the practical condition of the client. Otherwise, what's the use of submitting here? What the use of 100? So my case is that I have no way contributed anything.
If you argue in this manner,
I apologize for that.
this is not the way to argue before the court.
I apologize.
You have to wait for your turn.
Oblige.
I have no submission, lordship. Let the owner first appear, at least at this stage.
No,
This
you
is
are,
the first date, lordship.
you are only challenging the direction to
Direction
of pay and recovery.
And in the event of pay and recovery, the presence of the owner is required, lordship. So if we make the deposit and if the claimant withdraw the same, then what will be the very purpose of filing of an appeal without in the absence of the owner, lordship? So let notices go to the owner, let him appear. One chance may be given, lordship. We are ready to deposit. Because this is a different case. This is not just on quantum or on violation of policy condition. It is a case where the presence of owner.
Is waive করিছো নাকি? Notice. Notice waive করা পড়াকছো নাকি? No problem. The notice to respondent number 4 and 6.
4 and 5, lordship.
4 and 6 is waived.
Oh.
Who is the owner?
4, lordship.
From whom you will be recovering?
4, lordship.
And notice to respondent number 5 and 6 is waived.
Other insurance.
However, the applicant shall take steps for issuance of notice to the respondent number 4 by speed post as well as by usual mode within 4 weeks from the date of this order. What is the date in make appeal? Returnable on 9th of April. Itia last part. What was the last?
In the event of the is made by the
Insurance company, same shall be disbursed to the opposite party number 1, 2, and 3 / claimants after proper verification by the registry, subject to their furnishing an indemnity bond that to the effect that in the event in the connected appeal they are directed to deposit the said amount, they shall be ready to deposit the same. This, let this matter be listed accordingly.
Item 14.
Lordship, here is a similar issue, Lordship, pay and recovery, but here the issue is relating to the driving license.
Item?
Item number 14, Lordship.
Heard Mr. S.P. Sharma, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 4/11/2025 passed by the Motor Accident Claims Tribunal, Borpeta, in MAC case number 356/2021, whereby here also pay and recovery.
Pay and recovery, similar order, in the place of road permit, it will be the driving license.
Wherein the present applicant
And there is no 50-50 here, Lordship. The entire liability is fastened upon one insurance company, us.
the present appellant was directed to pay and pay a compensation amount of rupees 4,68,569 to the claimants, and thereafter where is the pay and recovery direction?
Pay and recovery direction, Lordship, in the interim judgment. Lordship, in the para 59. The first instance, and then the liberty to recover the entire amount from the insured, OP number 2, owner of the vehicle, in due course of time.
Last line. Not 4 lakh.
9 lakhs.
9 lakhs. 9,68,569. And thereafter recover the same from the owner of the offending vehicle. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of April.
See, here also we are ready to deposit.
This appeal is admitted. Let this appeal is admitted. Let the records of the trial court be requisitioned. Registry to take steps for requisitioning the records. Issue. Here we are issuing notice.
Let's say 50%. We are ready.
You are ready.
Yes, Lordship. Let them appear, then they will file a I, Lordship. This I may be disposed of.
Heard Mr. S.P. Sharma in I, learned counsel for the applicant. This application, interlocutory application, has been preferred by the Oriental Insurance Company Limited in connection with the MAC appeal number 83/2026, praying for stay of execution of judgment and award dated 4/11/2025, passed by the Motor Accident Claims Tribunal, Borpeta, in MSC case number 356/2021 during the pendency of the aforesaid appeal. The appellant was the applicant has been directed to pay the compensation amount of rupees. What is the total count? Rupees 9,68,569 to the claimants,
Interest of 9%.
along with an interest of 9% by the aforesaid judgment. Learned counsel for the applicant submits that the applicant is ready to deposit 50% of the awarded amount before the registry of this court as a condition for grant of stay of the execution of the impugned judgment and award. Stop considering the submissions made by learned counsel. The notice to the respondents, opposite party is waived and the prayer is allowed. The judgment and award dated 4/11/2025, passed by Motor Accident Claims Tribunal, Borpeta, in MSC case number 356/2021, shall remain stayed during the pendency of the connected MAC appeal number 83/2026, subject to deposit of the 50% of the awarded amount by the present applicant before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Obliged.
Item 15.
If please, your lordship, my lord, appeal on the ground of quantum, my lord. 50% will deposit, my lord.
Heard Mr. T. Kolita, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been filed by the Chola Mandalam MS General Insurance Company Limited, impugning the judgment and award dated 12/11/2025, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro at Gauhati, in MSC case number 818/2019, whereby a compensation amount of rupees 31,08,000 along with an interest at the rate. What was the interest?
9%.
Along with an interest at the rate of 9% per annum was directed to be paid by the present appellant to the
My lord, to the
opposite to the respondent/claimant. I have gone through
For
the
number one.
grounds taken in the memo of appeal. I have also considered the submissions made by learned counsel for the appellant. Stop. This appeal is admitted. Let the records of MSC case number 818/2019 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within a period of 7 days from the date of this order, returnable on 9th of April. List accordingly. This interlocutory application has been filed. Hayetu lawyer naam likhibo, Mr. Hard, Mr. T. Kolita, has been filed by the applicant insurance company in connection with MAC appeal number 84/2026, praying for stay of execution of the impugned judgment and award dated 12/11/2025, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro at Gauhati in MSC case number 818/2019. Whereby the present appellant was directed to pay an amount of rupees. How much?
31 lakhs, 8,000.
31 lakhs 8,000 to the respondent number 1/claimant. The aforesaid judgment and award has been impugned by the insurance company in the connected appeal. The said appeal has already been admitted and the notices are issued to respondent number, all the respondents. Stop. Learned counsel for the applicant submits that the applicant is ready to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award. Judgment and award. Hence, notice to the respondents is hereby waived, and the prayer and this interlocutory application is allowed. The aforesaid judgment and award shall remain stayed. Aforesaid impugned judgment and award shall remain stayed. No, the execution of aforesaid impugned judgment and award shall remain stayed during the pendency of the connected MAC appeal number 84/2026, subject to deposit of 50% of the awarded amount by the present applicant before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Much.
Item 16.
Let's say appeal preferred by the insurance company. Here also, let's say there was violation of policy condition, no valid driving license, and Learned Tribunal applied the principle of pay and recovery.
Lord Mr. S.P. Sharma, learned counsel for the appellant. This appeal under Section 173 of the Motor Vehicles Act 1988 has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 6/11/2025, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, Gauhati, in MSC case number 2528/2017, whereby an amount of rupees 17,40,000 along with an interest at the rate of 9% per annum was directed to be paid by the present appellant to the claimant's respondent. Stop. I have gone through the grounds of appeal as well as considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MSC case number 2528/2017 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 9th of April. List accordingly. You are ready to deposit. Heard Mr. S. Sharma, learned counsel for the applicant. This interlocutory application has been filed by the insurance company applicant in connection with MAC appeal number 85/2026, praying for stay of execution of the impugned judgment and award dated 6/11/2025, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, in MSC case number 2528/2017. During the pendency of the connected appeal, the aforesaid appeal has already been admitted and notices have also been issued to the respondents. The learned counsel for the applicant has submitted that the applicant is ready to deposit 50% of the awarded amount as a condition for grant of stay of the execution of the impugned judgment and award. Considering the submissions made by learned counsel for the applicant, the notice to opposite parties is waived and the prayer is allowed. The judgment and award dated 6/11/2025, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro at Gauhati, in MSC case number 2528/2017, shall remain stayed during the pendency of the connected MAC appeal number 85/2026, subject to deposit of 50% of the awarded amount before the registry of this court by the present applicant within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Item 17.
May it please your lordship, here I am appearing for Mr. A. Pacharji, my lord. I am praying for an adjournment because his father, my lord, passed away last week, my lord. He is in the native place, my lord. So he had asked me to take the adjournment for today, my lord.
Okay. Heard Mr. K. Kolita,
For A. Pacharji.
appearing for Mr. A. Bhattacharya, who submits that since the engaged counsel for the appellant is in bereavement, an adjournment may be granted. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter when?
My lord, second week of March, my lord.
Second week of March.
Some rituals are going on. my lord.
Let this matter be listed on 13th of March.
File up.
Orders, item 18.
Your Lordship. Lordship, this matter was listed before the Lojima Court on 24/10/2025. And the matter was placed before this court for a direction to the appellant to take step for respondents 1 and 2 through Dusty Lodge. And peruse of order dated 24/10/2025, Lodge. Lojima Court's order. 24/10/2025, Lodge.
Lord Mr. R. Sharma, learned counsel for the applicant, who submits that as per order dated 24/10/2025, this matter has been 24/10/2025 of the London Lawazima Court. This matter is listed before this court for issuance of a direction to the applicant for taking steps for issuance of notice on respondent number 1 and 2 through Dusty mode. Stop. I have gone through the records. Stop. The applicant is directed to take steps upon respondent number 1 and 2 within 7 days from the date of this order through Dusty mode. Returnable on 30th of
No, I need some time, Lordship.
30 April. 30 April. Stop. In the event the applicant is able to serve the notice on the aforesaid respondents through Dusty mode, he shall submit an affidavit in compliance thereto on the next date fixed. List accordingly.
Deeply obliged, Lordship.
Item 23.
Yes, Your Honor. In this case, we are supposed to file our affidavit in opposition, but we could not file the same as the petitioner in person was not a resident of Gauhati. And we could not serve the copy to him. Due to which we could not file the affidavit in opposition in time, Your Honor.
No. What is the submission?
Your Honor, actually, we have already prepared our affidavit in opposition, but we could not serve the copy to him as he is not a resident of Gauhati, Your Honor.
Serve him today.
You know, actually, there is a problem. The earlier affidavit in opposition filed by the signature authority, he has already been changed. A new signatory authority has been joined. So we have to took signatures from him.
How they will serve you copy?
Today they can serve on, by email they can serve.
You know, we can serve them.
You serve them.
Sir, I am having Tezpur address also, they are aware also.
You know, but in person, we could not find him in Gauhati.
You need not to serve him in the. Where do you stay?
Sir, generally I am, earlier I was staying in Tezpur, nowadays in Chandigarh, sir.
So you serve him through email?
Honor.
Heard.
Lots of one submission, lots of. Lot of times they have taken for giving objection, lot of times. So this is a matter of 1983, 84, Lordship, of the contract. This is arbitration matter, Lordship.
No, what is your prayer?
My prayer is something, sir. Sir, there was delay in filing an examination chief for by my advocate at Tezpur trial court. They could not file examination chief because some record was not traceable, which is not traceable, and it was not traceable for many years. Ultimately, they say, the London court say, then on final hearing, the advocate has not attended. That's why we have dismissed that continuation with the application for 5 months. Lordship, there were 2 applications. One were under section 5 of limited.
No. Don't be so. What relief you are seeking?
Lordship, one thing, though application there, one was decided by this honorable court in 2010 in my favor. That was also for delay. And on the delay, restoration of case.
In
is
this,
pending.
in this appeal, what is the relief which you are
The
seeking?
relief is, I have requested for the relief. It is therefore prayed that the Honorable Court please be satisfied the Miss J 2006 and restore the application as its own number. That's one.
Your condemnation of prayer was dismissed.
Dismissed, yes.
Okay, okay. Let them file. You provide your email ID to them.
Okay, I'll provide that. I will take, I've just now, I've received the, just now I received. Then Lordship.
Heard Mr. Ghanesham, heard the petitioner in person. Also heard Miss, what is her name?
Sahu,
M. Sahu,
behalf of Vega and Yon.
appearing for Assistant Solicitor General of India. Appearing on behalf of Assistant Solicitor General of India, who submits that though the written objection prepared by the respondent is ready, however, same could not be served to the petitioner as he is not a resident of state of Assam. On the other hand, the petitioner in person submits that the objection may be served to him through email also. Stop. The petitioner in person is therefore requested to furnish his email ID to the learned counsel for the respondent, who shall thereafter furnish send a copy of their written objection to the appellant in his mail. This shall be done before the next date fixed. When can we fix?
4 weeks. Your
Not 4 weeks. Why 4 weeks?
Actually, as I said, the earlier authorized signatory has already been changed, so we have to again take signature from the new authority. So we need some time, Your Honor.
Where that authorities?
Yes, Your Honor.
No, not 4 weeks.
3 weeks then, Your Honor.
What?
19th March.
Lordship, it is not true to me 19th month, either 16th or in April, Lordship. 16th of March.
Okay, April or the 13th.
April 21st, Lordship.
21st April.
Yes, sir.
Oblige, Lord. Oblige.
Oblige, Your Honor.
Item 24.
May it please your lordship. Your lordship, on the earlier occasion, there was a direction for taking steps to dusty service, your lordship, upon all the respondents. Dusty service has been done and affidavit to that regard has also been filed, your lordship. That is on record, your lordship.
This is a delay condonation application.
Lordship.
How much delay?
Delay of 80 days, your lordship. In this case, your
You are
lordship,
opposing?
respondent number 127 has entered appearance.
My
your
lord, will
lordship.
hear me for 1 minute. Let her finish, man. I'll not say anything.
But as regards your lordship, respondent number 8 and 9, dusty service is not completed, your lordship. Your lordship may peruse para number 3.
Eight and nine other mode of service?
We have taken steps only for dusty service, your lordship. The prayer was for dusty service only, your lordship.
Then why have you not served? If you have.
It has been returned back as, your lordship may peruse para number 3. It has been, say, in respect of the other 2 persons, the notices were returned back as incomplete address, your lordship.
No, Dusty is personal service. Who returned it back?
Yes, now, the persons were not found, your lordship. Report states in that way, your lordship. Otherwise, your lordship, they are the owner and the driver, and your lordship, there is no dispute as regards the involvement of the vehicle, your lordship. Payments have already entered appearance.
Yes.
My lord, if I may, my lord, in this case. So what is transpired in this case is this, my lord. I am yet to get a copy of the, because we had filed an execution case in this case. And at the time of filing an execution case, we got to know that there is in such kind of a case, the insurance company has filed an appeal. Accordingly, I had filed my wakalatnama, but my wakalatnama is apparently not tagged with the file, my lord. But the copy of IA is not served with me, my lord. If that can be given, and after 2 weeks, my lord, the matter can be taken up. I will also take an inspection.
Okay. In the meanwhile, you may take steps on respondent number 7, 8, and
Nine.
heard Miss P. Bhattakur, learned counsel for the applicant. Also heard Mr. A.B. Day, learned counsel
For respondent number 1 to 7.
appearing for respondent number 1 to 7, who submits that he has not yet
Got the copy of
received copy of the interlocutory application as well as the memo of appeal filed by the applicant. The applicant is therefore directed to furnish copies of the instant interlocutory application along with annexures to the learned counsel for respondent number 1 to 7 within a period of 2 days from the date of this order. The said respondents may submit their written objection if they desire to do so before the next date fix. In the meanwhile, the applicant shall take fresh steps for issuance of notice upon respondent number 8 and 9 by speed post within 7 days from the date of this order, 2 weeks, 3 weeks. 19th of March.
Obliged.
My lord, my name may be reflected in the
The
cause
name
list,
of Mr.
A.B. Day.
A.B. Day be reflected in the cause list as engaged counsel for respondent number 1 to 7 henceforth.
Deeply obliged.
Obliged.
Item 26.
Please, your lordship. My lord, here, both the parties have, my lord, come to a settlement and they've decided to live together, my lord. I have filed an additional affidavit, my lord.
So you're withdrawing?
Withdrawing.
Withdrawing. Heard Miss S.B. Chaudhary, the learned counsel for the appellant, who submits that during the pendency of this appeal, both the parties to the appeal have arrived at an amicable settlement and they have decided to live together as husband and wife. As such,
28.
May it please your lordship. Your lordship may peruse office note dated 24/2/2026, your lordship. Office note states that respondent number 1 has expired, your lordship. And as regards respondent number 2 and 3, no AD card has been received.
how many respondents are there?
There are 3 respondents, your lordship.
Whom you are appearing for?
Lordship, we are for claimant Nabakumar Goswami.
Make it sure.
Yes, Lordship.
You are appearing for
Nabakumar
Yes,
Goswami.
expired.
claimant number?
Payment respondent number 1 has expired, your lordship.
Has he expired?
No, Lordship.
Office note.
Lordship, we have not received the copy yet.
No, whom you are representing?
Nabakumar Goswami.
Respondent number?
Lordship,
Oh,
there is no.
you have to be sure at least.
Okay.
No, you must be knowing whom you are representing.
Lordship,
He may not be knowing.
Lordship, as my senior director, Lordship, he told that we are for claimant Nabakumar Goswami.
There are 2 claimants. No, take instructions, proper instructions. What is the name?
Baba Kumar Goswami.
Okay. So, respondent, who has expired?
Respondent number 1, Your Lordship. Office note, Your Lordship, a Paris office note dated 24/2/2026. It shows that respondent number 1 has expired.
Lordship, we have not received. the
Respondent
copy
number
and notice
2, Your
also.
Lordship, respondent number 1 is represented by respondent number 2, Your Lordship.
You verified whether one has expired or not.
Okay, Lordship. Lordship, but we have not received the copy yet.
Provide, Your Lordship.
No, but first you have to verify whether the one is alive or not.
Lordship.
Heard Miss P. Thakur, learned counsel for the applicant, learned counsel for the appellant. Also heard Mr. What is your name?
Ali on behalf of J. Kalita.
A. Ali appearing on behalf of Mr. J. Kalita, learned counsel for respondent number 1. On perusal of the office note dated
24/2/2026.
24/2/2026, it appears that notice issued to respondent number 1 has been received with an endorsement within inverted comma deceased. Stop. In view of the same, learned counsel for the respondent number 1 is requested to verify whether the respondent number 1 is still alive or not. The service report in respect of notice issued to respondent number 2 and 3 have not yet been received. When have you taken steps?
Lordship, steps were taken on 6/2/2026, Your Lordship.
Stop. The registry is directed to place the postal track consignment report of notices issued to respondent numbers 2 and 3 before this court on the next date fixed.
16.
March. So let this matter be listed on 16th of March.
Obligation.
30.
May I please your lordship? The matter may be passed for time being.
Why?
My senior is lagging another court. My lord, service to Hussein. Boy, otherwise, my lord, 197 days may be delayed. I do not know owner and driver because they file, I do not know the ground of filing of appeal.
You are for Mr. Paul, you are for?
I'm a respondent number 1, my lord. Insurance company. I have no objection, my lord. Owner and driver is.
And who is respondent number 2?
Maybe my lord, owner and driver, 2 and 3. I'm a 1.
No, why no steps have been taken against 2? Steps have been taken against.
Yes,
Who is the counsel?
my lord, the matter may be passed over for time being.
Okay, we'll take it. Let him come. Who is the?
Yes, sir.
Let him come.
For the timing.
Item 31.
I am appearing on behalf of RWCGC. If due to medical emergency, she is not present in the court. Matter may finally be taken up after 2 weeks. She is at Kolkata.
What is the matter?
This is regarding the
Delay.
condonation of delay.
I
in
is
filing
for
an
delay.
Land acquisition appeal, my lord. There were 2 cases, similar cases. Land were acquired from 2 different parties, therefore, among the same party. Therefore, two reference cases were instituted. In both the cases, compensation was enhanced. Against that order, they have filed 2 appeals. One appeal has with condonation petition. Condonation petition in case of other case has already been dismissed.
Dismissed.
Already been dismissed.
How much is the delay?
390 days. 390, it was dismissed. They preferred SLP before the Supreme Court. That was also dismissed, madam. Similar case, and this present petition is word by word same. Word by word same, no difference at all. That was dismissed finally by the Supreme Court also, madam.
Now what should we do?
My submission, madam, this.
But they are seeking
In her
adjournment on medical ground.
That is there.
There is no stay. Question of stay is no. So we are allowing the adjournment.
Because of the tendency, this Rana district judge is not proceeding with the execution case.
No, you tell district judge to proceed because the,
the accompanying has been dismissed, so they can place that before the court, my lord, on the next day.
the order.
They will place an affidavit also. That will be good, man. I hope that will help to decide the case.
Yes, you may file a written objection on the next,
Objection already.
stating those things, stating the dismissal.
Because it was subsequently.
No, that will help you as Mr.
After filing our counter, the Supreme Court has passed this order.
You bring it on record formally. We are giving one adjournment on medical ground. Heard Mr. A.R. Tahbildar appearing for Miss R. Devi, learned counsel for the applicant. How many applicants are there? Learned counsel for the applicants. Also heard Mr. A.C. Sharma, learned counsel for whom you are appearing for? Respondent number?
1.
I'm appealing for 2.
Respondent number 1, as well as Mr. K.K. Bhattacharya, appearing for respondent number 2. Stop. Mr. Learned counsel for respondent number 1 has submitted that in a connected matter which has arisen out of a
That was IA 1833, my dear.
Which has arisen out of what? There were 2 early cases.
3.
This is against LA reference 2 of 2020.
Reference 1 of that was 1. LA reference 1 of 2020.
How they are connected? 1 and 2? How LA1 and LA2 are connected?
Which is same day's order among the same parties. Among the same parties. 2 cases were there only because lands were covered.
Order was passed on same day.
Passed on same day.
Okay.
Between same persons.
Common order or separate orders?
Separate orders in both the cases.
Facts
are similar. The present petition is also exactly similar to that petition.
Riser, in a similar case where the parties are same, the present applicant had prayed for condonation of delay in that case also. However, said application was dismissed. Stop. Against the same, the applicant of that case approached the apex court by preferring an SLP. However, the said SLP is also dismissed. Stop. On the other hand, Mr. Tawbildar submits that the counsel for the applicant is indisposed and has gone to Calcutta for her treatment, and on that ground, an adjournment is prayed for. Considering the grounds stated by the learned counsel for the applicant, the prayer for adjournment is allowed. In the meanwhile, the respondent number 1 may file an additional affidavit to bring on record the fact of dismissal of the connected IA by this court as well as by the apex court.
That IA we have already brought. Only SLP order.
Okay, fact of dismissal of the
SLP.
SLP preferred by the present applicant in a connected case before the apex court. The prayer is allowed. Let this matter be listed 16th of March. Is it okay?
Maybe third year.
No, it may have to be late. 16th March is okay.
That day also, let's see, because her brother's kidney transplant will be there, let's see. So the time frame we can say on 16, let it be listed again.
16, will she be there?
Cannot be said, let's see. I can say.
So how much time you want? You will not get unlimited
No,
time.
let's see, 16, let it be on 16, she may come also on that.
16?
Because the process is on. For the
Okay. Let it be on 16.
Item 32.
Obliged.
Lordship, in this case, we have filed one petition to restore the case. Lordship, the case was dismissed for default. Our name was not shown in the court list, Lordship. This is the reason, that is why.
What was dismissed?
Lordship, Miss case, Lordship, 91/23, Lordship. This was dismissed on 22/3/2023.
Miss case?
Miss case 91, Lordship.
So, miss case. This miss case is for restoration of
Yes,
what?
Lordship. Yes, Lordship.
This is for what?
91, Lordship, to restore, Lordship, to set aside the order of dismissal, Lordship. This was dismissed as our names were not shown, Lordship.
Which one was dismissed? Miss case 9
MAC appeal was dismissed, Lordship. MAC appeal 43, Lordship.
was dismissed.
Yes, Lordship.
Thereafter, you have filed 91
Yes, Lordship.
for restoration.
Yes.
Any objection
Yes, we have already filed our objection.
in miss case?
Yes.
But I don't see any orders in.
As per them, the name of the advocate is not shown on the particular date. It is 22nd March 23.
No, where have you filed objection? In which case?
Against the restoration.
In miss case, there is no order.
91 MC 91 of 23.
ये ऑर्डर मिस केस में होगा मिस केस 91 हाँ yes
As per them, the name of the council was not shown in the cause list on 22nd March 23 on the date of dismissal for default. So prior to that, the case was listed for 22nd February 23. On that date also, they have not given the cause list for that date.
On that day also, it was not shown, Lordship.
So the cause list should also have been given. This one. So Lordship, subsequent to that, after the dismissal, we have filed a petition in before the Honorable Tribunal for issue of Bakizai certificate. So Lordship, kindly from to page 9, annexure 1 of an objection.
no just I mean the applications are not tagged properly.
On the last date, it was not there, but that was called for lordship. I think it should have been in the any record.
Miss case is their objection.
Their objection was called for lordship. That maybe in
They
other.
filed prior to the last day.
It may be in other record locking.
Why it is in other records?
It was called for lordship on that day.
In MSc appeal, no, MSc appeal has already been dismissed.
Yes, lordship. Dismissed for default.
Then how it is fixed?
Lordship.
This IA 2098 is for
209 is for staying the process, lordship. On the other date, lordship was placed to stay, lordship. Bakizai proceedings is initiated and warrant of arrest also was issued, lordship. Lordship was placed to stay that proceeding till today, lordship. Warrant of arrest was issued.
but IA and MSc appeal are not in existence.
Yes, lordship. MSc appeal that is to be restored, lordship. That's our prayers.
Where is your objection?
Our objection is they have not filed the pause list of the previous date.
No.
Wherein they have not appeared. That's one.
You
Our
filed,
objection. We've already filed yours. I don't know whether the registry has put it up for their misplaced for some reason. We've already served the copy to them also.
okay. It is there. It is there. Yes, what is your objection?
Your Honor, subsequent to the dismissal, we have filed a petition before the Honorable Tribunal for issue of Bakizai certificate. So on 27 February, the report was put up. It is at Annexure 1, page 9 of my objection. The report was put up and the notice was issued on 27 February 24.
Yes.
Coming to the Annexure 2, it was fixed for 6 June 24. It is at Annexure 2 order Honorable 2. Today's the case is fixed for service report and filing objection if any by the opposite party insurance company. The honored consent for the claimant is present and file copy of postal receipt along with postal tracking report. Opposite party insurance company is absent. So on that date they were absent. Again, it was fixed for 5th August 2024. We again took steps. It was duly served. On coming to Annexure 3 here, next page. On 5th August, this is in the third para of Annexure 3. It appears from the perusal of the case report that judgment was delivered by tribunal on 30th November 2013 and opposite party insurance company limited was directed to make payment to claimant. Till date, opposite party insurance has not deposited the awarded amount to the claimant. Now this Ms. J case was filed by petitioner claimant has filed a petition dated 29/11/20 under section 174 of the MV Act to recover the awarded amount from the opposite party insurance. As the opposite party insurance is absent without any step, let issue Bakizai certificate against it immediately. Petitioner claimant shall take necessary. So the Bakizai certificate was issued. They have got ample opportunity to appear after service of notice, but they did not appear.
No, it is not a question of appearing before the Bakizai court. Their appeal was dismissed.
Yes.
Because they failed to appear before this court.
So, on the previous date also they did not appear. So they have not given the cause list also. For the grounds which they have taken.
But on the day when it was dismissed,
Yes.
on that day their name was not reflected.
But they are saying on the previous date also it was not shown. So if it was not shown the previous date also, it is fine.
So what is your?
The cause list would have been given of the previous date.
Okay, no. What is your objection to?
It is only objection, Your Honor.
That they have failed to submit the cause list. Okay.
And this submission is with respect to the stay petition. We have received the copy
No,
of the
no.
stay petition.
Stay petition we will decide later on.
Yeah.
First, whether to restore or not. The objection is against stay petition only,
No,
restoration.
restoration.
Okay, we'll dispose of the restoration application.
Lordship, if Lordship permit, I may say have some submission, Lordship, in this area.
Regarding
Their statement, what they had done in tribunal, Lordship.
no, tribunal question would be later on. First, let us see whether it is to be restored or not. Why you failed to appear?
Yes, Lordship, that is our cause. This is given, Lordship. We have only given the date when it was dismissed actually, but in the other date also it was not there, Lordship. It is available in the website.
On the
also.
date of dismissal, your name was shown.
No. We have given the cause.
They have not appeared on 22nd February 2023 and 22nd March 23. Because
Okay.
in March it was dismissed for default. As per them, it did not appear. They have annexed.
We have annexed the date when the case was dismissed,
But
Lordship.
22nd February 23 for this, they have not annexed.
Any Lordship cause list when one name is shown.
Miss
that-
case number 91.
Yes, Lordship.
Miss case number 91. This application is filed under what provision? Wrong provision. It should have been under order 41 rule 19.
One protection of Lordship may not be barred in the disposal.
Therefore, you will quote everything wrong everywhere.
Yeah, it is Lordship one mistake on our part also. So in the lower court, I have given this not of high court. Also. It is actually of lower
Heard Mr. A.J. Sakya, learned counsel for the applicant. Learned counsel for the petitioner, sorry. Also heard Mr. What is your name?
Yes, Sakya, Anupam Sakya.
A. Sakya, appearing for
Respondent number 1.
respondent number 1 claimant. This application has been filed. No, this miss case has been registered on filing of an application for application by the petitioner / insurance company for setting aside of the order dated 22/3/2023 and for restoration of the readmission of the appeal, readmission of the for readmission of the MAC appeal number 43/2023, which was dismissed for default by a coordinate bench of this court on 22/3. Learned counsel for the applicant has submitted that the MAC appeal number 43/2023 has been filed by the present petitioner impugning the judgment of the motor accident claims tribunal. Which motor accident claim?
List 2.
Guwahati.
Lordship, anything on the
Motor accident claims tribunal number 2, Guwahati, in MAC case number
1612/2006.
1612/2006, whereby the present applicant was directed to pay an amount of rupees 2,07,500 along with an interest at the rate of 6% per annum. To the claimant. He submits that on the date of passing the impugn order, that is 22/3/2023, when the aforesaid MSc appeal was dismissed for default. The name of the engaged counsel for the appellant was not reflected in the cause list. And as such, the engaged counsel for the appellant were not aware that the matter would be called on for hearing on that date. Learned counsel for the applicant, petitioner submits that there was no mala fide on the part of the appellant in not appearing before the court when the matter was called on for hearing. The reasons for not appearing before the court was only that they were not, that the engaged counsel was not aware about the listing of the matter on the said date. In support of his submission, learned counsel for the petitioner has annexed the cause list, relevant cause list dated 22 March 2023. On the other hand, Mr. A. Saika, learned counsel for the claimant / respondent, submits that before 22 3 2023, when the aforesaid MSc case, MSc appeal was dismissed for default, the appeal was also listed on another, which date it was listed?
22nd February 2023.
On 22nd February 2023. And on the said date also, it was dismissed on 22nd March. It was earlier listed on 22nd February. क्या लिखा? On the said date also, nobody had appeared for the appellant. However, the appellant has not clarified their absence on the previous date. Neither any cause list has been of the said date has been annexed along with their application stop. I have considered the submission made by learned counsel for the parties. It appears that the MSc appeal number 43/2023 was dismissed. Who is P. Sharma?
I don't know. We have explained in our paragraph.
He is not engaged.
No. It was earlier on engaged counsel of Mr. B.K. Purkaisto. He has left for Delhi. So thereafter, we were engaged, newly engaged. We have explained everything in our paragraph 2, 3, 4 of our application.
Dismissed for default on 22nd March 2023. It also appears that the said appeal was listed as item number 11 in the cause list of court number 20 on that day. It also appears that though the name of Miss P. Sharma has been shown in the cause list as engaged counsel for the appellant, name of the present counsel, namely Mr. A.J. Saikia was not shown. Learned Counsel has, no, in the petition filed by the present petitioner, it is contended that the appellant has earlier engaged one Mr. B.K. Purkayastha in the aforesaid appeal. However, later on 27/1/2020, the present counsel, namely Mr. A.J. Saikia, was engaged. Stop. Since the material on records, including the cause list dated 22/3, (2023) also shows that the name of the engaged counsel for the appellant, namely Mr. A.J. Saikia, was not reflected in the cause list on that day. There is every likelihood that the appellant, the engaged counsel for the appellant, may not be aware about listing of the said matter. Hence, this court is of considered opinion that the said grounds may be regarded as sufficient cause which has prevented the engaged counsel for the appellant to appearing before the court when the appeal was called on for hearing. As such, this court is inclined to allow this miscellaneous case and direct the readmission of MSC appeal number
43.
MSC appeal number 43/2023. Stop. The registry shall list the said MSC appeal after a week.
Lordship, there is IA was also there. IA also may be restored. IA number is Lordship there. We have made it clear. IA number civil 2337 of 19. That is record is there.
MSC appeal along with the interlocutory application number. Interlocutory application number
2337. It is dear Lordship 19. IA civil 2337 19.
IA civil 2337/19. List the matter again next week at the date. 6th of March. This miscase is accordingly disposed of.
The
5th of March.
Lordship, till then, Lordship, arrest one will be state. And that is order is passed in Lordship IA civil 2098. Lordship.
Till that day, the warrant of arrest issued by Bakijai certificate officer against the certificate debtor in BJ case number 89/2024 within bracket MSC T shall remain stayed.
We need to file our objection also, Your Honor.
In those cases, you may file objection.
With respect to this stay,
You may file objection.
but the time is too short. Your
It
Honor.
is, no, it will be restored on that day. you, if possible, you file on that day, or you see,
Not possible, Your Honor.
then you may pray for time on that day. It may be granted. Order will be only in this case.
May I please, Your Lordship? My Lord, I am sorry for interruption, my lord. My time being item, my lord, 30. It may take enough.
Why?
There is a IA, my lord.
No, why at?
Timing pass over, my lord, because
Okay.
you are the paper. Because there is a delay of 197 days, I have no objection. Bagis of the, my lord, as one to is complete.
Who are you?
I am the one.
Owner,
Insurance company.
owner or insurance?
Insurance, I am the, yes, I am the.
You are not opposing.
They filed for enhancement.
You are claimant.
Amendment or enhancement the awarded compensation.
Heard Mr. S.A. Ahmed, learned counsel for the applicant. Also heard Mr. R.C. Paul, learned counsel for the
Respondent number one.
respondent number
What?
one insurance company. Considering the fact that the connected appeal is filed by the applicant for enhancement of the compensation awarded to him, the notice to other two respondents is waived. This application under Section 5 of the Limitation Act has been filed by the applicant Anwar Hussain, applicant slash claimant Anwar Hussain, for condoning the delay of 190 days in preferring the connected MAC appeal, whereby the applicant has impugned the judgment and award dated 11/7/2024 passed by the Motor Accident Claims Tribunal Darong in MSC case number 54/2018. Learned counsel for the applicant has, why delay?
Delay, my lord, he has at paragraph 5, my lord,
Has explained the
paragraph 5.
cause of the delay in paragraph number 5 of the instant interlocutory application. He has basically stated, he has mainly contended that due to the difficulty in movement, this is an injury case.
Yes, ma'am.
Difficulty in movement faced by the applicant due to injury sustained by him in the accident. He could not prefer the connected appeal within the prescribed period of limitation. Stop. Mr. R.C. Paul, learned counsel for the insurance company, considering the grounds stated in the application by the applicant for the delay, does not raise any objection against the prayer for condoning the said delay. Stop. I have considered the submissions made by learned counsel on both sides and have gone through the materials available on record. Considering the submissions made by learned counsel for the parties, as well as grounds stated in para 5 of the delay of the instant interlocutory application to be sufficient cause which prevented the applicant in approaching this court for filing the connected appeal within the prescribed period of limitation, comma, the delay of 190 days in preferring the connected MAC appeal is hereby condoned, and this interlocutory application is disposed of. Registry to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it. This interlocutory application is accordingly disposed of.
My name may be shown in the
Name of
appeal.
Mr. R.C. Paul may be shown as engaged counsel for the insurance company in the cause list when the connected appeal would be listed.
Item 33.
Deeply obliged.
Lordship, I am sorry, Lordship, in item number 32, my name may be shown, Lordship, otherwise I will also miss, Lordship.
Item number 32, name of Mr. A.J. Soikia may be shown as engaged counsel for the appellant in the cause list henceforth. Item number.
Hearing this application has been filed by the legal heir of the deceased, Your Lordship, for vacating the interim order, Your Lordship.
What interim order?
On 10/3/2023, there was an order. 17, Your Lordship, of my petition card. The order passed by the Workmen's Employee Compensation Group Gauhati has been explained, Your Lordship. On
Oh,
10th
vacating the stay order, no?
Yes.
Yes.
Your Lordship, I will have objection. Your Lordship, what happened in the WC case is that the insurance company was not even implicated as a party respondent. And against the insurance company, the award was passed. And we were deprived of the right to file written statement and also adduce evidence, whether the policy was valid or not, whether there was any infirmities in the policy or not. We could not even verify because we were not even a party. So that is why we are challenging the award.
Let them, you file written objection.
Okay, Lordship. And Your Lordship, the matter is ready for hearing.
Lordship, in
The
here,
matter
Your
will-
Lordship, regarding my friend's submission, Your Lordship, they have submitted that no opportunity was given. And the same, I have also the same submission, Your Lordship. We have also not been provided any opportunity.
Where?
If Your Lordship will remand back this matter, Your Lordship, then also I have no problem.
No problem.
The matter may be heard
Then,
in its full extent, Your
then the appeal will be heard. We are fixing a short date for
If
it.
if Your Lordship will hear the appeal, then this application, Your Lordship.
Okay. Let the connected. No. Heard Mr. A.M. Khan, learned counsel for the applicant. Also heard Mr. S. Datta, learned counsel for the insurance company. This interlocutory application has been filed by the applicant praying for vacating the stay on execution of the impugned order in MFA number 17/2023 passed by this court on 10/3/2023 in IA number 646/2023 has been made. Learned counsel for the insurance company submits that he has an objection regarding the prayer made by the applicant. Stop. However, both the councils are ready. Both the councils have submitted that the connected appeal, that is MFA number 17/2023, may be heard instead of hearing this instant interlocutory application. Stop. Considering the submissions made by learned counsel for the parties and considering the fact, trial court records are there,
Yes, Lord.
considering the fact that the connected MFA is ready for hearing, list this matter along with the connected MFA on the date of hearing. List the connected MFA number 17/2023 for hearing on which? Any day. No,
Okay, Lord.
no 5th, next week, 12th of March,
Okay.
12th of March.
Along with this,
Item 34.
Yes.
Is it for?
I am appearing for respondent number one.
One, your lordship. So far as former respondent, your lordship, I have taken steps, your lordship, they have not yet. But the office note showing that on, as of 4/2/2025, I have not taken any steps.
You have not taken steps.
I have taken, your lordship, but I don't know why. I need to cross check with my clerk, your lordship.
Heard, Mr. What is your name?
Alia Chaudhary, your lordship.
R.A. Chaudhary. What is your name?
MS Mondal Lordship for respondent number one.
Also heard Mr. M.S. Mandal, learned counsel for respondent number one. On perusal of the office note, it appears that the appellant has not taken any steps for issuance of notice upon respondent number one. And other respondents, stop. The appellant is directed to take fresh steps for issuance of notice upon the other respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 9th of April, list accordingly.
Lordship, there is IA, your lordship.
I am vacating the stay.
Lordship,
You have not taken steps.
steps I have taken, that is why I need to check your lordship.
Very,
Lordship,
no,
lordship, I have not the receipt right now, but I have provided to my clerk everything, your lordship.
no, you have provided to your clerk is not a justification.
I take the receipt tomorrow, yes, sir. Tomorrow, lordship, I will. On the receipt.
Tomorrow is holiday.
Sorry, lordship, on Monday. The submission may be recorded, your lordship. I can.
Heard. Mr. R.A. Chaudhary, learned counsel for the applicant. Also heard Mr. M.S. Mondal, learned counsel for the respondent number one. On perusal of the office note dated on 4/2/2026, it appears that the applicant has not taken any steps for issuance of notice upon the other respondents. So, however, learned counsel for the applicant submits that he has already taken steps and seeks a few days' time to produce the relevant document within bracket acknowledgement issued by the registry. The prayer is allowed. Let this matter be listed again on 6th of March. if the applicant failed to satisfy this court that he had complied with the directions of this court for taking steps, the interim order of stay of execution case 2020/2025 shall be vacated. Stop. List this matter on 6th of March 2025.
Lordship, one more submission, Lordship. In that case, Lordship, they are performer respondent. Their name may be struck down, Your Lordship.
No. This system of striking out everybody, you first issue notice. Let us see whether it is.
Obliged, Lordship. Obliged, Lordship.
Item 35.
May I please, Your Lordship?
Yes.
May I please, Lordship? Lordship, service is complete, Lordship. At TC are not received, Lordship. Step taken, Lordship, 21/1/2026.
How many respondents are there?
One.
Only one. Okay. Heard. Miss, what is your name?
They Akhtar.
J. Akhtar, learned counsel for the appellant. Also heard Mr. T. Kolita, learned counsel for the respondent. It appears that the records of MSC case number 14/2022, which was requisitioned in connection with this case, has not yet arrived. Issue reminder for the same. List this appeal again after receipt of the aforesaid record on 25th of March.
Item 36.
Same, Lordship. Same, Lordship. 36 item.
Sole respondent.
Same order.
Yeah, my lord, I would like to submit one thing, my lord. Whether it is necessary or not, I don't know, my lord, because since we are made a party in the appeal, my lord, because we are going to indemnify the insured owner of the vehicle, they ought to have been made party perhaps, my lord, because without his presence, we are nobody, my lord, because we are
They have not made party.
not made party.
Yes, they have to be
They have to be
made
made party, because
party.
we are in the role of indemnifier, my lord. If the beneficiary is on record, my lord, how can we be made party? That is the question, my lord.
Yes, this trend of striking out name and slowly, earlier the trend was making party and then striking out. Now the trend is not even making a party.
Just to affect the service, my lord.
That may sometime affect their case. You have
We are
to,
going to indemnify them only, because if he is not there, the indemnify the beneficiary under the policy. So you are in fact not a stranger to that litigation, but in fact.
there is a provision in order 41. If they have not contested the case,
Yes, madam.
then you can dispense with. But if they have filed written statement before the trial court
Fine.
and had contested the case, then they are to made party. This issue you take up formally while hearing of the case.
My lord, my lord, my lord.
Then
That
we will
goes in
decide.
that provision, my lord. Even I'm not aware, my lord, that particular provision, my lord.
There is a provision. Anybody in bar?
Please.
Mr. Sakia or Ms. Bhattakur, that order 41, that the defendant who has not contested the claim may not be required to be a party in order 41 rule 12. Okay, you look for there is a provision somewhere.
My lord, I will look into it. my lord.
Same day. What is the date?
25.
25. You also look for that provision where the defendant has not contested the claim. He need not to be made party or notices need not to be sent to him. There is a specific provision.
Item 37.
May I please, Lord? My lord, in this case, I have filed this petition for releasing the deposited amount, which is deposited with the registry. My lord.
Any objection?
It is on quantum, your lordship. Regarding withdrawal, I have no objection.
Item Kiman. Heard Mr. K.U. Ahmed, learned counsel for the applicant. Also heard Ms. P. Bhattakur, learned counsel for the respondent. This interlocutory application has been filed by the applicant/claimant praying for directing the registry to disburse the 50% of the awarded amount deposited by the insurance company before the registry in pursuant to the direction, in pursuant to the order dated 10/12/2025 passed in
IS Civil 4019 of 2025.
IS Civil number 4019 of 2025 in connection with the
Make appeal.
MAC appeal number 551/2025. The learned counsel for the respondent, learned counsel for the insurance company raises no objection as the appeal filed by the insurance company is mainly against the quantum of the compensation awarded to the claimant. Stop. Hence, considering the submissions of the counsels, the prayer is allowed. The registry shall release the 50% of the deposited, 50% of the awarded amount deposited by the insurance company to the present applicant/claimant, applicants/claimant. Who is applicant? Dipulal Saha.
Dipulal Shah, my lord.
Shri Dipulal Saha, after proper verification. This interlocutory application is accordingly disposed of.
Obliged.
What is
Lordship, in
the
the main appeal, respondent number 1 has already entered appearance, and as regards respondent number 2, he has been struck off, your lordship. So service is completed. And lordship, LCR has been called for on 7/2/2026. It has not been received as yet, your lordship.
heard Ms. P. Bhattakur, learned counsel for the appellant, and Mr. K.U. Ahmed, learned counsel for respondent number 1. It appears that by order dated 10/12/2025, the name of respondent number 2 has been strike out, and hence the appearance of parties is complete. However, it appears that the record of MSC case number 135/2021 has not yet been received. Stop. Hence, issue reminder for the same. Registry to take steps. List this matter. 22nd of. No, it may be in the month of April also.
Your lordship.
After Bihu.
After Bihu.
23rd of April.
Obliged.
Item 38.
Here, my lord, I am appearing for Mr. A. Pochaji, my lord. His father has passed away, my lord. Similar submission I made in item number 17 as well, my lord.
Stop. Heard Mr. T. Kolita appearing for Mr. A. Bhattacharya, learned counsel for the applicant, whose father has passed away, Mr. Kolita has accordingly prayed for an adjournment on behalf of Mr. A. Bhattacharjee on the aforesaid ground. The prayer is allowed. Let this matter be listed on 13th of March.
Item 39.
Yes, my lord, listed for the first time, my lord. Notice may be issued, delay of 273 days, my lord.
Heard Mr. T. Kolita, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been preferred by the applicant insurance company, praying for condonation of delay of 273
Corrected, my lord.
days
Subsequent.
in preferring the connected appeal, whereby the judgment and award dated 16/12/2024 passed by the Motor Accident Claims Tribunal Nagaon in MSC case number 186/2021 has been impugned. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual modes within 7 days from the date of this order, returnable on 9th of April.
Item 40.
Lordship, matter has come for the first time, there is delay of 72 days.
Issue notice. Bakiyat Sabha. List this matter on 9th of April.
Item 41.
I have a combination of delay. 547 days. That's it. My learned is appeared for the respondent number 1 to
1,
3.
2, and 3.
You are opposing. You will be opposing.
No objection, madam.
No objection.
No objection. 5 and 6. 5 and 6.
You are for claimant opposite party.
Claimant.
From the date of the dismissal of the review petition, there is no delay. That's it.
There is no delay. That is why I accept this.
So that's it. Delay may be on the
Okay. Heard Mr. K. Bhatto, learned counsel for the applicant. Also heard Miss. Yes, what is the name? Didi Roy. Heard Miss Didi Roy, learned counsel appearing for respondent number 1, 2, and 3 / claimants. This interlocutory application has been filed for condonation of delay of 547 days in preferring the connected appeal. Stop. Learned counsel for the respondent claimants has submitted that since against the original award, a review application was preferred by the insurance company, and after disposal of the review application, there appears to be no delay.
Review, madam.
After review,
Yeah.
hence she is not opposing the prayer for condonation of the delay. Considering the submissions made by learned counsel for the claimant respondent as well as by the applicant, notice to other respondents is hereby waived. Hereby waived. Also, considering the grounds stated in the instant application, the delay in preferring the connected appeal is hereby condoned, and this interlocutory application is disposed of. The registry is directed to register the connected MAC appeal, and list the same for admission after a week on a date to be,
The date may be fixed 10th of March,
okay, on ten,
Okay.
okay, on 10th of March.
10th of March.
The registry is also directed to reflect the name of Ms. D.D. Roy as engaged counsel for the respondents / claimant in the connected appeal in the causeless henceforth.
Lordship, I have a prayer, Lordship. I'm sorry, my lord. Lordship, item number 39, my lord. Date is fixed on 9/4/26. Lordship, I have some problem, my lord, because my father's annual Shraddh ceremony is
You
here.
suggested it
Lordship, any date in the first week, my lord.
first week of
April.
April first week.
Or after due vacation also, my lord.
24th April.
24th.
Item number, how much?
39.
Item number 39, 24th April.
Highly obliged.
Item 42.
Yes.
So I listed for the first time, Lordship, delay of 75 days.
Heard Mr. S.P. Sharma, learned counsel for the applicant. This application under section 5 of the Limitation Act has been preferred by the applicant, praying for condoning the delay of
75, Lordship.
75 days in preferring the connected appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order. Returnable on
9th.